at least at this point, adhere to some strict time limit. So first up to testify will be Lucas Vebber, speaking in favor, although I don't know that we have a particular issue, so give us some favorable testimony, Mr. Vebber. Thank you.
The form was it's not tailor-made for informational hearings like this. Sorry. All right. Good morning, Chairman Jacobson and task force members. Thank you for the opportunity to testify today, and thank you also to Jelly's Market for hosting us. It's always good to be on the road at these kinds of hearings. My name is Lucas Vebber. I serve as Deputy Counsel at the Wisconsin Institute for Law and Liberty, or WIL, based out of Milwaukee. We appreciate the Speaker's leadership in creating this task force and all of your commitments to transparency, accountability, and constitutional balance to look at Wisconsin's rulemaking process. Wisconsin's Constitution is explicit. The legislature writes laws, the executive branch enforces them, the judiciary interprets them. Those are principles that we all learn in fourth grade when we're visiting the Capitol. Yet over many decades, the legislature has transferred broad policy-making authority to administrative agencies. The result is that unelected bureaucrats, often unaccountable, issue rules that carry the force of law, shape public policy, and impose real costs on Wisconsin families. For decades, you, our elected legislators, have had robust oversight powers to oversee these bureaucratic actions. However, the recent Evers v. Markline decision, also known as Markline 2, has significantly changed that dynamic. By limiting the legislature's ability to review or block rules without going through a full bicameralism and presentment process, the court has made it significantly more difficult for elected lawmakers like yourselves to oversee agency actions. If no changes are made, Wisconsin will increasingly be governed not by laws passed by the people's representatives, but instead by regulations written by agencies with little direct democratic accountability. Before getting into some proposed solutions, I just want to highlight why this matters in human terms. Every regulatory action has consequences and imposes costs. Sometimes, of course, they're necessary costs and necessary consequences, but those ultimately fall on the people you represent. To illustrate the real-world impact, I just want to highlight a couple of quick examples. A couple of years ago, DATCAP proposed a commercial pool code rewrite. So commercial pools at like hotels or water parks have different standards than your personal pool in most people's backyards. Obviously, there's a lot more things that go into the commercial pools. The pool code rewrite would have applied those commercial rules to Airbnbs, short-term rentals. If you had a hot tub or a pool at your Airbnb, you would have had to upgrade it to commercial standards under that rule. One Lake Geneva owner that we talked to, her above-ground pool was told it could never qualify under the commercial code. Another received a $150,000 estimate to rebuild her pool completely to comply with it if the rule went through. Thankfully, in that case, the legislature was able to stop that rule back in 2002 and prevented DATCAP from enforcing the commercial pool code standards on short-term rentals. Another example would be the Department of Public Instruction imposed an hours of instruction requirement. Our state law imposes an hours of instruction requirement overseen by the Department of Public Instruction, is a better way to put it. Shortly before COVID, it came to light that DPI had been enforcing this hours of instruction requirement differently for public schools and schools in a parental choice program, despite the fact that the statutory language was identical. They were public schools, traditional public schools were allowed to use what's called virtual instruction to satisfy their hours of instruction requirement. Choice schools were not. Again, the statutory requirements were the exact same. That was just done not even by administrative rule, but by guidance, essentially, from the Department of Public Instruction. We filed a lawsuit against that, got a declaration that that policy was unlawful, and schools in the choice program were allowed to then use virtual learning. This was right before COVID. I think like 2 or 3 weeks after we got that judgment, the COVID pandemic hit. And while any parent will tell you now that virtual learning is the worst thing that's ever happened in the history of the world, I think we're all pretty sick of it. It was vital at that time to maintain those kids and keep everybody in school. So what those stories show is that when agencies overreach or rely on outdated rules, real people are bearing the cost. It can be promulgated rules, attempts to promulgate them, other agency actions that have rule-like effects. Since the Markline 2 decision, we have already seen DISPUS advancing building code changes. They're going to raise the cost of building houses. DATCAP has proposed a livestock fee increase, in some cases up to 1,700%. I know there's been some changes there. Without meaningful legislative oversight, these burdens will continue to grow. These aren't partisan issues. No matter who the governor is, the legislature needs to have more oversight power going forward. With that being said, I'd like to highlight several policy solutions for the committee to consider. I'll first highlight several of the reforms that have already been introduced in the legislature, and then I'll talk about some additional reforms that this task force could consider as your important work carries on. The first is the sunset review of administrative rules. This is Assembly Bill 274. This has already had a public hearing, so I don't want to go too much into it, but Wisconsin is the 13th most regulated state in the nation. That number is based on regulatory restrictions in our administrative code. It is the second most regulated in the Midwest, meaning that families and businesses here in Wisconsin face more restrictions than almost anywhere else in the region. Yet once adopted, these regulations stay on the books in perpetuity in most cases, unless the rule itself has some kind of a self-repeal in it. The Sunset Review Bill creates a 7-year rolling review for all rules to expire. It just puts an end date on those rules, so they have to be rewritten and readopted. Promotes accountability, reduces outdated burdens, keeps regulations aligned with current economic and technological realities. Many states already use a similar review system in Wisconsin. Several governors have led successful efforts to reduce regulatory burdens along these lines. In Virginia, Governor Youngkin cut nearly 30% of the regulatory requirements, which is estimated to save residents over $1.4 billion annually in that state. Building code reforms alone reduced construction costs by more than $24,000 per home in Virginia. That's real money at a time when we need more houses. Even modest improvements would generate significant long-term economic gains here in Wisconsin. Another bill that's, again, already been out of committee and is now pending, I think, in the Rules Committee in the Assembly is Assembly Bill 277. This is the regulatory budgeting bill. So oftentimes regulatory budgeting models require agencies to repeal a set number of rules for every rule that gets implemented at the federal level. I think we've seen, like the Trump administration has said, 10-1, I think is the trade-off they have there. That approach can sometimes be gamed by agencies offsetting a new rule with smaller rules. Also, there's some practical problems, like how do you define what a rule is that's being repealed in that? I don't know if it really works for Wisconsin. With this bill, this proposal focuses on something that I believe to be more meaningful. When an agency wants to adopt a rule that would increase compliance costs, it has to identify real measurable savings elsewhere that would offset those costs. If it cannot, the rule has to be affirmatively approved by both houses of the legislature. That just recognizes that there are times when a rule has to go through that's going to increase costs, and the legislature just needs to know that and have the accountability for it. Under this model, agencies estimate the compliance costs of any new rule and propose offsets by modifying or eliminating outdated requirements. If they can't balance it, the legislature gets to determine whether that's justified or not. Other jurisdictions, again, have had success with similar approaches. British Columbia in Canada used regulatory budgeting to cut nearly 40% of its rules, contributing to measurably stronger economic performance. This approach forces agencies to make trade-offs and stops them from continuously adding new burdens on families, small businesses all around the state, and ensures democratic accountability. Again. Two more bills that are currently pending. One is AB 275. This is the bill relating to court challenges for the validity of administrative rules. Like that bill I talked about earlier against the DPI, it would essentially allow a fee shift. If somebody brings one of these cases and they win, they would have a chance to get their attorney fees paid. AB 276 is a scope statement reform bill, again, getting kind of in the weeds of administrative rulemaking. Scope statements are kind of the start of the rulemaking process. Agency will release a scope statement. It puts the public on notice that a rulemaking is occurring. They should start paying attention. If it's a topic that is of interest to them or may impact them or their business, gives them an opportunity to start following it. Right now, scope statements are being used in some cases for multiple rules, which can be very confusing to people who follow these things, who follow rules. And you can use one scope statement to do an emergency rule and a permanent rule. Again, it just creates a little bit of confusion. What AB 276 says is that for every scope statement that's out there, it can only be used to promulgate a single rule. Just kind of cleans that up and just makes it a little clearer, a little more transparent what government agencies are doing here in Wisconsin. With those bills that are already, again, introduced, I want to talk about some additional possible reforms for the committee to consider as you do your important work on this topic, and would be happy to follow up and meet with any committee members to go into more detail on these too. But the first would be a constitutional amendment to restore oversight authority with the legislature. So I think the legislature should certainly consider a constitutional amendment to restore its ability to oversee the rulemaking process as it has for decades, and other powers that it has specifically delegated to the executive branch. One of the primary problems with the Mark Line 2 decision is that for years, The legislature has delegated its power away to agencies on the assumption and condition that it maintained oversight over that rulemaking power. The court struck down that agency oversight, but maintained the delegation of power. So as the legislature, you said, hey, agency, you should be able to do this, but we're going to be able to have oversight at the back end. Now there's no oversight at the back end, but the agency is still allowed to do it. I think that's a dangerous dynamic. Several states already give their legislatures, I think it's 6 states, give their legislatures explicit constitutional authority to review or block agency rules. Wisconsin should not be an outlier in this way. I think that's a great model to follow. Any amendment, of course, should be carefully tailored to cover only delegated powers like rulemaking. The goal is not to interfere with core executive functions, but to reaffirm that when an agency exercises rulemaking, which is a legislative power, elected lawmakers retain that very important final say. That's the way it has been historically in Wisconsin for decades. That principle reflects how most states understand the separation of powers and how Wisconsin operated, again, for years leading up to the Markline II decision. Obviously, a constitutional amendment is a hard task. It requires 2 consecutive legislatures and then a vote of the people, but I think that's one of the most important things that you all could consider. A couple other key reforms here would be to amend the REINS Act threshold. So the REINS Act was designed to ensure that when an agency proposes the most expensive rules or the most costly rules, $10 million or more over a 2-year period, that the legislature had to weigh in, had to approve those rules. Basically, it required democratic accountability for the most expensive agency regulations. One thing that we've seen since that has come into place is that the cost of rules have always, almost across the board, been below the $10 million threshold. A simple reform to consider would just be to lower that number, to widen the field and get more rules to be subject to that. I don't know what that number could be. We can get you a list of other states and what they do who have passed this similar reform, but something for you to consider. Another proposal would be to review broad grants of agency rulemaking authority. So many agencies have been given broad grants to write rules. Often, wasn't intended to be that way, but it's just a broad grant that says so-and-so shall adopt rules, period. There's also a general grant of rulemaking under Chapter 227, which allows agencies that haven't been explicitly granted authority to write rules, to drop rules. I think that 227 grant of rulemaking should be repealed altogether. Those broad grants should be made specific so that you explicitly tell agencies what they should be writing rules on. And those are important reforms. I think having a catalog of all forms of rulemaking grants somewhere that everyone can have and look at and know would be a very helpful step in this way. The third would be a nonpartisan office to review regulations. So under current law, when state agencies propose a rule, they do their own economic impact analysis. Obviously, I'm not saying that agencies are gaming the system here, but there's sort of an incentive to not hit the $10 million threshold, of course, because they'd be subject to the REINS Act. Too often these estimates really understate the true cost of compliance. It's difficult to get them to be accurate, of course, because they're estimates, but many states address this by using a dedicated nonpartisan office to independently review the legality, economic impact, and necessity of proposed regulations. Creating a similar office here in Wisconsin would give legislators and the public a reliable, neutral assessment rather than relying solely on numbers generated by the agency advancing the rule. So this would really strengthen oversight as well. It'd be similar to what Scott and his team do at Ledge Counsel when they review rules. Would be using just completely unbiased expertise to review these things. I think it'd be an important step you could go forward. Emergency rulemaking reform is the last proposed reform we have for you today. Wisconsin's emergency rule process is all too often used for just routine policy making because it's easier than going through the permanent rule process rather than for true actual emergencies. Agencies can adopt emergency rules under a broad public welfare justification. Those rules can remain on the books for 150 days and then can be extended several times after that. It creates a pathway for agencies to implement major policy changes without going through the full rulemaking process. There is a time and a place for emergency rules. They certainly are necessary in some cases, of course, but this simple reform would just tighten that definition of an emergency to a genuine imminent threat. We could cap an emergency rule, lower the threshold from 150 days to something like 90 days, unless the legislature extends it, and require agencies to provide more of a factual justification for using that process. Thank you for your time today. I'd be happy to answer any questions from the committee. I do, again, very much appreciate all of your efforts to be this way and looking at this important issue. And if we can ever be a resource to any of you or your staff, please reach out anytime.
Very good. That's very helpful. Do we have questions from committee members? Rep. Sortwell.
You mentioned that